Most people assume that if you're raised like family, the law will treat you like family. But in Florida, that's not necessarily true, at least not for inheritance. In Timmons versus Ingrahm, a real Florida appellate case, Frank Sr. had 2 adopted children from a prior marriage and a second wife, Myrtle, who had 4 biological children. Frank's will and trust spelled out that upon Myrtle's death, the remaining assets would go to his lineal descendants. That term has a specific legal meaning under Florida law. It includes biological and adopted children, but does not include stepchildren unless they've been legally adopted. After Frank died, Myrtle used her power of appointment to try to give all the trust assets to her own children. That attempt would have disinherited Frank's adopted children entirely. The adopted children sued, and on appeal, the court said it clearly. Lineal descendants means descendants in the direct line, not stepchildren. Florida trusts and wills are interpreted according to the legal definitions unless the document clearly shows a different meaning. Frank's will did define children broadly for some other purposes, but it did not redefine lineal descendants, and that made all the difference. This case is a real warning. If you want a stepchild to inherit, you have to say so clearly in your plan.